The next case to come before the court is In Re TG and AJ. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time, and I will try to alert you when you move into your rebuttal time. The arguments are being recorded, so please introduce yourself, keep your voices up, stay behind the podium. You should not use the names of children, minors, victims during your argument. You can refer to them with initials or terms like the child or children. We have read your briefs and we're ready to proceed, and I would just ask counsel, would you like to reserve time?
I would, Your Honor, if I could reserve 5 minutes.
Okay, very well, and we're ready when you are.
Thank you, Your Honors, and may it please the Court. Andrew Karras on behalf of Appellant Mother Antoinette Grant. This case asks the following. Can a parent in a dependency proceeding be required to perform their case plan objectives enthusiastically? And does a parent's unfriendliness toward child services caseworkers bear upon what is in a child's best interest? I submit that the answer to either of those questions is no, and accordingly this Court should reverse and remand. We have raised two issues as a formal matter on appeal. One, that the trial court erred in granting the agency's request to award legal custody of the children to their respective placement resources. And two, that the trial court erred in not granting a 6-month extension of the agency's temporary custody to give mom more time to work on her case plan objectives. Obviously, these issues overlap. Analyzing either requires looking at what's in the child's best interest, and then either as part of that best interest analysis, looking at mom's case plan compliance, or as it relates to the 6-month extension as a specific prong of that analysis. So given this overlap, I'm going to start by just highlighting what I think are important provisions of the record. And I can proceed to address the issues in order at that point, obviously, if the Court has any questions, and I'm happy to field them as they come up. At the outset, I would just emphasize that this case was premised on two things when it was initiated. One, that the children were not enrolled in school. And two, there was a video that surfaced with mom using what all the parties agreed below, or it was an instance of excessive corporal punishment toward the oldest daughter, toward AJ. At the time of the sunset dispositional hearing that this appeal was taken from, truancy was no longer a live concern. That had been addressed. The kids were in school. And so I would submit that the lodestar of the case at this point is, did mom address the mental health, the anger management concerns that led to that instance and necessitated removal? So I would highlight for the Court a couple of things that the case plan required specifically of mom. She had to make an appointment for a mental health assessment. She did that. She was required to sign releases so the agency could keep track of her appointment attendance and how those visits to counseling were going. She did that. She was required to follow her provider's recommendations. I would submit in the main she did that. Above and beyond what the case plan required, Ms. Brandt sought out anger management counseling on her own initiative at her own expense. Her testimony at trial, I think this is supported by the record, was that she benefited a great deal from that counseling. To which she testified that, because of the therapy she's received, she no longer sees physical discipline as the answer in any parenting circumstances. It's just not a parenting technique she endorses anymore. Given that corporal punishment in and of itself is not legal in Ohio, that it cannot give rise to dependency, neglect, or abuse unless it is tantamount to the offense of child endangering, I would submit that she overcorrected the basis for removal, at least in terms of what the law requires. So case plan compliance is, of course, a component of determining what's in a child's best interest. It's not, of itself dispositive. So our first issue, what is in the child's best interest, which is the essence of a legal custody determination. A couple of other provisions from the record I would want to highlight. Either the kids wants to be with mom, live as a family. It's undisputed. The agency's own testimony was that there were no concerns with the safety or adequacy of the home. Again, the remaining big plank, the remaining basis for removal was corrected in a manner above and beyond what the law requires. Her case plan progress on mental health and anger management counseling was, I would submit, otherwise remarkable, as reflected by the record. The trial court obviously credited the agency's testimony that it was dissatisfied with the level of her engagement at her counseling appointments, that they believed she was evasive, that she wasn't engaged fully. A few things. First, I would submit that that's not entirely supported by the record. She did, I think Mr. Stranahan, the counselor who was put on to testify, did acknowledge that she discussed traumas like the death of her own parents, the death of TG's father, among other things. He admittedly, at the fault of the agency, didn't consider what would have been the most relevant and recent records of her counseling. And the agency's other caseworkers testified that while he couldn't describe the specifics of her testing with the second provider, that's Everwell, their understanding was that she was forthcoming and engaged appropriately in counseling with that provider. So setting that aside, and perhaps being stuck with the trial court's factual findings being what they are, I would also submit that engaging with your case plan with a particular subjective feeling, it's not a case plan requirement, and it puts parents in a really difficult position to attend these mandatory counseling and feel a particular way about it. I would also highlight that mom reliably attended all of her visits at the Family Interaction Center. The trial court held that there were essentially demerited mom for not proceeding to a less supervised form of visitation. And to that point, I would say that the agency's own testimony were that following the August 17th, 2023 incident that we talked about in our brief, where there was a physical altercation between AJ and mom, visits, at least in terms of parenting, qua-parenting, proceeded with no issues, that they went well for, again, from August 17th until the time of the sunset disposition wrapped up. So that was February 16th. That's a period of 6 months. So, that mom did not proceed to a less supervised form of visitation. I submit that the record just reflects that that is because the agency didn't want her to. So, to speak to our second issue, whether the trial court should have granted a 6-month extension, that turns on what's in the child's best interest. I would just reference everything I said previously as it relates to the first issue. Whether there was substantial case plan progress and whether reunification would occur or whether the children would otherwise be permanently placed within the extension period.
Does your client have residual visitation rights?
Yes.
Okay, but that's not encompassed in this journal entry.
In the trial court's journal entry?
Right.
So I believe the magistrate's order did articulate, as is a component of a legal custody award.
So shouldn't residual parenting rights be in the final journal entry?
I think it probably should be, as a matter of record keeping. If that is error, we may be stuck with a waiver forfeiture problem there, to the extent that we could have raised that. And there is language, otherwise I think adopting the magistrate's decision.
So wouldn't that, if they adopted that language, shouldn't that be attached to the brief? All of the orders that make up the final journal entry? If multiple orders make up a final journal entry, should they all be attached to the appellant's brief?
I believe that is what the appellate note rules require. prior, and to the extent that that was an oversight in our opening brief, I apologize for that. So as it relates to mom's case plan progress, the agency in its brief, I'll quote from its brief, is that mother has been mostly engaged in services throughout the duration of the case. I would submit that's a big concession. By its very nature, a parent's request to extend an agency's period of temporary custody presupposes that not every issue facing a family has been solved.
Counsel, let me ask you a question. Was there an appeal pending regarding TG at the time of the legal custody hearing?
Not with respect to TG. So AJ and TG, the subjects of this appeal, are mother's daughters. There was a separate proceeding now disposed of by this court involving the sons. Procedurally, what happened was at the time initially set for sunset disposition, AJ's father appeared and made a request for counsel.
And you are moving into rebuttal, but I apologize, I asked you the question.
But just procedurally, the girls' cases were continued at that point and set for a separate hearing.
Thank you.
Thank you, Your Honor. May it please the court. My name is Aaron Campbell. I represent Summit County Children's Services in this matter. The agency would ask this court to affirm the decision of the trial court below that place these children in legal custody of their respective caregivers. Now, I want to first start off by addressing the 6-month extension issue. Under the 6-month extension was not objected to by the mother in this case, and so it was not reviewed by the trial court below in reviewing the objection of a legal custody decision. So that was raised for the first time on appeal. The mother has forfeited the 6-month extension for all but plain error. The mother does not raise an argument regarding a 6-month extension, a plain error argument for this case regarding a 6-month extension. The trial court indicated that that was dismissed as being untimely because it was filed in between the 2 days of the hearing for the legal custody trial. So it was a legal custody, excuse me, the 6-month extension motion had not been filed before the start of the trial.
Counsel, I understand your arguments, but I guess the first thing that comes to my mind is the termination of parental rights being the equivalent of the death penalty, in a criminal case. And then also, we're looking at the best interest of the child, of the children here. So you have these procedural arguments, but what was the reason why a 6-month extension was not necessary in this case?
This is not a permanent custody situation. There are residual parental rights in this case. Well, it has been said.
I agree. I misspoke. I apologize. We've got 3 of these today, so.
I understand, Your Honor. So,
But the point is, we're still looking at the best interest of the children.
that's correct, Your Honor. The ultimate disposition hinges on a single determination of what is in the best interest of the child. However, what goes to the merits of a 6-month extension was not considered by the trial court. While there is a determination as to the best interests of the children, a 6-month extension has its own merits under 2151.415. That requires clear and convincing evidence. It has its own issues as to standing, and it's not simply a denial of the legal custody motions. A 6-month extension is a brand new order that requires the agency to continue providing services for an additional 6 months. And then that sets a new dispositional hearing following that extension of custody. Whereas, as the mother argued in her reply, if the court had simply just denied the pending motions for legal custody, the court could have had a new trial as early as the following week, taking new motions and new evidence, as opposed to 6 months later. So there are some significant procedural differences as opposed to denying the motion for legal custody, maintaining status quo and just setting a new hearing, or holding that out for 6 months, setting a new standard for that dispositional hearing in 6 months. And those are significant procedural differences that were not considered by the trial court below.
And again, that's procedural. What was why was it not in the best interest of the children to have a 6-month extension?
There was ample testimony presented that the best interest for these children was to be placed in the legal custody of their respective caregivers. And the mother has also raised an assignment of error as to the legal custody decision there. That was supported by by a preponderance of the evidence. Now, the review of the legal custody decision is by the manifest weight of the evidence. Mother has argued that that should be a sufficiency of the evidence under In Re ZC. However, that was a decision by the Ohio Supreme Court considering very specifically permanent custody and the standard for review under permanent custody. Paragraph 18 of that decision, the conclusion by the Supreme Court, very narrowly held that that sufficiency or manifest weight analysis is limited to permanent custody decisions. As I cited in my brief, In Re MF, this court has consistently held that the review of legal custody is a review of manifest weight of the evidence. This supports to determine whether it is, whether the trial court has clearly lost its way or whether it has issued a finding that is an egregious miscarriage of justice. And that's not what happened here in this case. There were competing motions for legal custody. The mother did have a pending legal custody motion regarding AJ in this case, but the agency had filed legal custody motions for both children. Both parties were able to present their evidence as far as legal custody. Both the relatives who were awarded legal custody testified in this case. AJ had been with what was identified as her godmother for the previous 8 months. Her attorney at the outset of that case stated that she wished to be placed in the legal custody of her mother, but the attorney also said that if she couldn't go to her mother, she wanted to remain where she was, and that was where, with her godmother, where she was ultimately given legal custody. TG had been with her paternal grandmother for a year throughout this case, and the testimony was presented for both caregivers that the children were well bonded with their respective caregivers. They were receiving adequate care. The guardian ad litem testified that TG was doing well and was very well bonded with her paternal grandmother. TG did not indicate she wanted to return to her mother. She was bonded also with her siblings in order to stay connected with her siblings. There was also testimony presented that the respective caregivers were facilitating those sibling visitations, and that will continue without the agency involvement. There's no dispute that the mother, in this case, loves her children. They have an adequate bond with each other, but the issue in this case was whether the mother was going to be able to remedy the problems that led to this case coming within a reasonable time. Now, there was some discussion from mother regarding the case plan compliance. The reason case plan engagement is not dispositive for legal custody or a 6-month extension, because the case plan is not meant to be just a list of check boxes that the court weighs and says, is there enough check boxes here to grant a 6-month extension or to award legal custody? This case plan is a roadmap to assist the parties in remedying the problems that led to removal. There were significant concerns that led to the removal in this case. It wasn't just the children weren't involved, weren't in school or a disciplinary issue. The complaint had significant allegations that there were issues of domestic violence in the family, that the mother had engaged in a physical altercation, not just with one of the children, but with that child's peers, as well as the peers' parents. And the mother had testified at the legal custody trial that she believed that this case came about because she got into a domestic dispute with one of her paramours, and that he had called Children's Services and had made up allegations regarding her mental health.
Was the anger management part of the case plan?
Yes, it was, Your Honor.
Okay.
That was included as part of her mental health.
Okay, and did she pay for that?
Testimony was that she had chosen not to engage in the agency's recommended services. She had taken an online course on her own at her own expense. However, the testimony was also that came very early on in this case. I believe it was prior to the legal custody motion that the mother had filed early on in this case that was ultimately denied. subsequent to attending and completing that anger management services, there were still significant concerns regarding the mother's ability to control her anger issues. There was the incident between her child and her. There was a physical altercation at the visitation center. And there was some dispute about what ultimately led to that physical altercation. But
So what are the residual parenting rights here? It's not in the final order. Does she get to see the children unsupervised every other weekend, or what are those parameters?
If I recall correctly, that the magistrate's decision had left visitation to the discretion of the ultimate legal custodians, but that was not raised as an issue on appeal. That was not objected to either in the initial objection to the magistrate's decision.
So there is visitation, but it's a vague order about the parameters being up to the custodians.
You're correct, Your Honor, the visitation was not included in the final order following the objection. But it was, if I recall correctly in the record, the magistrate's decision had left that up to the discretion of the legal custodians. And that was something that was not disputed. That question was posed to the legal custodians, and there was no dispute that that's something that the parties all believed that they could work out. In addition to the physical altercation with the mother and AJ at the visitation center, there were other issues throughout this case concerning anger management, even up to near the trial date. There were some threats made to one of the caregivers at the courthouse, and the mother didn't dispute that she had made them, but she claimed that she was simply joking. But that didn't seem apparent from the witnesses who had testified. It didn't seem like she was joking.
Some threats, what were the threats?
The statement, I believe, was that the mother had told the caregiver that she didn't take good care of the child, that she was going to hurt the caregiver, and that she meant it, or something near to that effect. Also concerning is that the mother had lost her job only a few months prior to this trial because she engaged in a physical altercation with a coworker at work. And there were some concerns with the mother's ability to provide basic needs, including her ability to provide adequate money for basic needs for the children and herself. She had testified, the mother testified at the trial that she was self-employed at this point, but did not verify how much income she was receiving with either the guardian ad litem or children's services. So that was also a significant impact in the court's weighing of legal custody between the mother and the respective caregivers. There was no dispute that these were adequate relatives or non-blood kin for these children, and that the children had a significant bond with them, and then that they were in a well-loving and appropriate home. And there was some significant dispute that the mother was going to be able to resolve these anger issues within a reasonable time. Therefore, it was in the best interest for these children to be placed in the legal custody of their respective caregivers, and this court should find that was presented, but the decisions from the trial court were not against the manifest weight of the evidence. The trial court did not clearly lose its way in weighing the evidence for the best interests of this family and finding that these caregivers were going to be the best legal custodians for these children. So if there are no other questions, I would rest on my brief.
Hearing none, thank you, counsel.
Thank you.
And counsel, you will have 4 minutes, 31 seconds for rebuttal.
Thank you, Your Honor. On the error preservation issue, I would first just ask the court to take a hard look at the record. I think the transcript reflects that, at least the magistrate communicated, I think it's in my power to sua sponte make a request for a 6-month extension. I think the magistrate and then the trial court's analysis considered the prongs that would be attended to a 6-month extension request, in their analysis. I believe the trial court's order has a specific finding on whether reunification within 6 months or not was likely. Obviously, there's a best interest analysis that is contained throughout the trial court's decision, mom's case plan compliance is also part and parcel of that analysis. So Setting aside, formal issue preservation concerns, I think, these were the issues that were live in the hearing. This court, in the case actually involving the two sons that were disposed of, whose case was disposed of in an earlier hearing, noted that courts are not limited to the custodial options requested by the parties before it. Juvenile courts have broad discretion in fashioning a disposition in a dependency adjudication, as the courts are charged with protecting the best interests of the child. And again, given the analytical overlap between a request for legal custody, a request to extend temporary custody by 6 months, I would suggest that this court is at least well equipped to address the 6-month extension issue on its merits. To talk for a moment about what the ZC case says with respect to the standard of review. It is true that ZC was a permanent custody case. It wasn't, it didn't arise out of a request for legal custody like this one did. That said, it distinguished between what appellate courts traditionally had applied, an abuse of discretion standard in private rights of action emanating out of divorce or other domestic relation proceedings versus cases like ZC, and I would submit like this one, state-initiated action where parties can frame the issues as the record presents and as they sort of see fit on appeal. And so I would suggest that this court's own precedent often has examined legal custody determinations in accordance with manifest weight principles. In our brief, we've set out reasons why we think we have a manifest weight argument here, but you're not exclusively permitted to consider challenges to legal custody on those grounds, and you can consider sufficiency or other issues as parties appropriately raise them. A couple of quick points about the record. That anger management, I would just ask the court review the contents of the case plan in making its decision. I don't believe there is a specific prong for anger management counseling, and to the extent mom sought that out and that it spoke to the problems that underlie the case, I think that is to her credit. As it relates to the testimony about mom's employment, mom's job, it was not something that precipitated the events of this case that mom was unable to maintain a healthy and safe home for the kids, keep them clothed, keep them fed. It is true that that she didn't respond to a request for income verification made on the eve of the sunset disposition hearing, but there's no evidence, there was no demonstration of some attendant impact on the child's perspective environment in the home in the record. Mom's ability to care for the kids, again, as I said, her parenting was never seriously an
I'm
issue.
going to have to ask you to wrap up.
And with that, we would ask that the court reverse the remand for further dispositional proceedings. Thank you very much.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again. I'm sorry.